My name is Natasha, so that's what you can call me. You don't have to advocate or Bassingthwaghte, Miss Bassingthwaghte or whatever. Just Natasha is fine. I will be doing applications, but it's probably a good thing to, at the outset, also just say why applications would be preferable for some. Trials are more exciting because there's a lot happening in a trial. It's not predictable, so it gives you a lot more excitement because you have witnesses that you have to deal with, and you know with people. You've all been magistrates. You've experienced these things, so on and so on. So you know how unpredictable trials can be. Some of us prefer the applications. They are nice and clean up to a certain point. You get no surprises. You know exactly what is there because everything is in the papers. So there are certain matters or certain types of cases that you cannot do by way of application. Those are specifically identified by legislation, like liquidation and insolvency proceedings. Those are, for instance, things that you cannot do by way of trial action. So they must be done by application. Divorces, for instance, are things that you cannot do by way of application. It might change, I don't know, when the law changes, if divorces become simpler, but at this point in time, you cannot do a divorce by way of an application. Now, in between those two extremes, and you've seen there, I've also identified illiquid claims for damages because you need to lead evidence in order to prove your damages. And normally that kind of thing, it would be fairer to the parties to allow for cross-examination, for instance, because sometimes these things, if it's on paper, it's nicely put, but once you put the witness in the box, they don't tell the same story necessarily. Okay, so in between those extremes, you have a choice as a litigant, whether you want to bring a matter by way of application or by way of action proceedings. Now, that choice is dependent on mainly one factor, and that is whether or not a dispute of fact may arise. Okay? So that's how you would decide whether you come by way of application or not. So applications are generally encouraged in this because they are faster and they are simply less costly, or they're supposed to be. They can also become very costly depending on what the parties do. But fortunately, as judges, you can now regulate how the proceedings are conducted, and if there is any party who's busy with delays and abuse and those kinds of things, you have to rein them in as the judge. So you need to be able to pick up when somebody is busy with an abuse of process, whether they are busy with a delay, and that's where you have to step in as a judge and call parties to order. And that's pretty much the basis or the foundations of the new case management system, is that the judge is in control of the proceedings, just as it is in action proceedings, is in the application proceedings. The difference is in application proceedings, the judge only becomes involved after the pleadings have been filed. Unless something arises, like an interlocutory that comes mid-pleadings, if I can say, call it that, then a managing judge would already become involved at an earlier stage. So, the question that one would ask yourself is whether there is a real and substantial dispute of fact. So it's not just any dispute of fact which would decide whether you should have come by way of an application or an action. So there must be a real dispute of fact. So this case, Room Hire, Company versus Jeb Street Mansions, it's a case that's been referred to in our jurisdiction quite often. That's basically the locus classicus on whether or not, on what is the discretion of a judge. So what the case says, and this is, I've taken this from the head note, but you can go through the case, and in particular, I think the relevant parts are on page 1166 or 61. It will come up later on. But so in interlocutory applications, it's a different story. Okay, so sometimes even in trials you have interlocutory applications, and there will be disputes of fact that will arise. But so we're not talking here about interlocutory applications. We're talking about the main or substantive application. So in substantive applications, you should not come to court if you suspect that there might be a dispute of fact as an applicant. You should not come by way of application. So where there is no real dispute of fact, there's no reason for delays in the expenses of a trial, and motion proceedings are generally recognized as permissible. So where there's a dispute of fact, the court has a discretion as to how the matter must proceed. Now there's a reference to Rule 9 there, but in our jurisdiction, and I think that's probably very old rules. Yeah, that's even before our previous rules. So here, the relevant rule is Rule 67. I trust all of you have your rules with you. Okay. So when a dispute of fact arises, the court has a discretion as to what must now happen with the matter. And there are a number of things that the court can then do. So the court can decide whether it will hear oral evidence, or it can refer the matter for trial. In that case, the court will then decide whether the affidavits will then constitute the pleadings in the case, or whether the parties must actually file pleadings. So your affidavits, they serve a different purpose than pleadings generally, but if this happens, they could be used as pleadings, and the parties can then supplement the affidavits with evidence. And the third one is that the court can then dismiss the application with costs, and that would normally happen if it is apparent from the papers that the applicant should have realized that there would be a dispute of fact. So the court would then have to look at what is in the affidavits that have been filed to see, should this applicant have known, based on facts within their knowledge, that there would have been a dispute. So parties don't just come to court without there being a fight going on. So prior to the pleadings being filed, the parties would have had an exchange of letters or words or whatever they would have done. And in that, during the course of that interaction, the parties would have been able to pick up whether or not there would be disputes of fact, and whether this issue really just concerns an issue of law. So a dispute about the law is not what we are talking about here. Okay? So it must be a factual dispute, not a legal dispute, because a legal dispute can be determined on the papers. So the court will just take the facts as they are set out in the papers and apply the law. So if the parties don't agree on the applicability of whatever law that they bring up, that is not the determining factor. That is something that the court can determine by itself without even having further evidence from the parties. Okay. As I said, if the matter is referred to trial, the affidavits can be used as pleadings. So the founding affidavit would be your particulars of claim, the answering affidavit would be like your plea, and the replying affidavit would be like a replication. Or the court can say, no, the papers are a mess. I want you to file proper pleadings as if you were going through a trial now. Then the parties would have to file a particulars of claim, a plea. So it might happen that the other party might want to do a counter claim of sorts. You can also have a counter application. So that might also be on the papers already. So in that case, then the court might say, no, if the respondent wants to do a counter claim, so I'm referring you to trial, and you must file particulars. You must file pleadings, not affidavit. We're not going to use your affidavits. The affidavits will be there. They are on oath, and they can be used in cross-examination if the matter is referred to trial, or even if it's referred to oral evidence, obviously. what is in the affidavit will be used in cross-examination or evidence in chief. What will normally happen in an application is that the respondent will, almost as if a knee-jerk reaction, will say there are disputes of fact, and the applicant should have known that disputes of fact would arise, and he should not have come by way of application. It's your duty as a judge to determine whether this is an attempt to delay the matter, or whether this person is being genuine, or whether there is a genuine dispute of fact, let me put it that way. Because, as I said, it's almost a knee-jerk reaction for a respondent to do that, to try and get the application dismissed on the basis that there are disputes of fact. Okay, so remember, there are the three things that the court can do within its discretion if there is a dispute of fact. And what the court would want to avoid is that if a person comes to court by way of an application where the matter should properly have been brought by way of trial, then it will, in most cases, under those circumstances, it will then dismiss the application instead of putting the respondent through the whole process of first deciding whether one must refer for oral evidence or for trial or whatever. But those are the extreme ones where you can see, or the applicant could have seen beforehand, that there would be serious disputes of fact. Whether the applicant should have foreseen this, as I said, would always depend on what's the history behind the case that has come to court, and that's what the court normally would look at. So, but it's for the court to first look at, is there really a dispute of fact? It can't just take the word of the respondent and say, yes, there is a dispute of fact. This is your role as the judge. So the JP has asked me to make a list of the cases that I have referred to. I will do that, and that will also be shared with you. And I will probably add a few more in the process on the relevant topics. It's just like pleadings in a trial. So the plaintiff will state his case, and he has to make certain allegations that are material for his case in order for him to be able to succeed with his case. Now remember, I said affidavits in an application serves a totally different purpose. Not totally different, but it serves a different purpose than pleadings in a trial. Because in a trial, you have an opportunity to lead evidence. With an application, the idea is that there should not be any oral evidence. So the evidence must be in the affidavit. So when the applicant files his affidavit, he must state all the facts that he relies on. He must also provide all the evidence that he needs in order to prove those facts for his case. So when the respondent answers to the founding affidavit, he has to say, I admit this and I deny that. And if he wants to say that, you can confess and avoid, you can say, I admit A, B, C, and D, but actually it happened in this context, for instance. So you will have, similarly as you would have in a trial pleadings process, you would have somebody making statements or allegations, and the other party must admit or deny or confess and avoid and that kind of thing. And the respondent obviously can also provide more detail to counter whatever case the applicant is trying to make in his founding papers. So from there, from a reading of the affidavits together, you will then be able to determine what are the disputes that arise from the papers. So depending on what the applicant says, what the respondent admits or denies, and in the reply, the applicant might actually come and admit things that the respondent says. So you then have to look at all the affidavits to determine what are the disputes. Okay. So, as I said, in the room hire case, the court sets out the circumstances under which a dispute of fact arises. And the first one is, and this is what we were talking about now, is where the respondent denies all material allegations and produces positive evidence to the contrary. So the plaintiff says, I drove in a northern direction and I was on the left-hand side of the road, and the respondent approached me and he was in my lane, and the respondent answers and says, I deny. The applicant was actually on my side of the road. You would not have that kind of case, obviously, in an application, because that would be a trial action. But just simply to illustrate that. Okay. So that's the first set of circumstances in which disputes of fact could arise. So the respondent, so applicant made certain allegations which are material to the cause of action that he's coming to court with. Okay? Remember, he has to prove his case on his affidavits. We'll get to the founding affidavit and what it must contain, but basically, the applicant has to state all material allegations together with all the evidence he would need for him to succeed on his case, because he cannot come in reply to come and make his case in reply. It has to be in the founding papers. Okay. So, if the respondent then denies those material allegations, there would be a dispute of fact. Then the second basis, or the second set of circumstances, is where the respondent admits allegations of the applicant but makes allegations which the applicant disputes. There's three sets of affidavits. The applicant speaks first, the respondent answers and denies certain things, admits certain things, and he says something else, which the applicant then in his replying affidavit comes and denies. Okay. Then you have a dispute of fact. So the applicant could, the respondent could also come and say that he doesn't have personal knowledge of what the applicant is talking about, but he says the applicant must prove his case. Sometimes it happens that whatever allegations the applicant makes are only within his personal knowledge and the respondent does not know. And it's open to the respondent to come and say, I don't know what he's talking about, but he must come and prove his case. Okay, so he doesn't provide any facts to the contrary. He doesn't come up with a defense of sorts. He just says, I don't know, but I deny it. I deny it in the sense that I'm putting him to the proof of it. So he doesn't have contrary evidence. He doesn't know. So actually, he can't admit or deny what the applicant is saying. So, but he says it's his applicant's case. He must come and prove those allegations. Okay. In the fourth situation, you have the respondent coming and saying, it's very similar to the third one, where the respondent comes and says, I can't lead any evidence to the contrary, but I want the applicant to come and prove his allegations by way of oral evidence. So this is where the courts have said that if the situation, the fourth bullet point situation arises, it is up to the respondent to actually ask for the matter to be referred to oral evidence. And if the respondent doesn't do that, he runs the risk of losing the case, because he has not provided the court with anything to counter what the applicant is saying. In 3, the respondent would be saying that he doesn't know what the applicant is saying, he doesn't have personal knowledge of those main facts, but he denies them and he wants the applicant to prove the case, and he himself wants to give evidence to show that the applicant and his opponents are biased and untruthful. So he wants to test the credibility of the applicant or whoever is deposing affidavits on behalf of the applicant. And he wants an opportunity to show that the facts that the applicant is relying on are untrue. So you can do that through the process of cross-examination by basically testing the evidence of one witness against the other, or even contradictions within what one person is saying himself. So a person can say one thing at one moment, and the next moment he says something and it changes his version and so on. So that is what the respondent wants to do in this case. In the fourth instance, the respondent says he cannot lead evidence himself or through others to dispute the truth of applicant's statements because the statements are peculiarly within the applicant's knowledge. But he puts the applicant to the proof thereof by giving oral evidence, which will then be subjected to cross-examination. So again, he's trying to say, I want to test his evidence under cross-examination, because it's easy to put something on paper. And often, the affidavit is drafted by a lawyer who obviously uses nice words and can state a story, tell a story in a nice way. But the minute the witness starts talking, he sometimes has difficulty to stick to that story because it's not his own words. And that is why the respondent would say, come, I want you to come and speak under oath, and I want to challenge you on what you are saying in cross-examination and see whether you can still stick to your story. So those are the four situations. And in the last one, the court would say, but the respondent, and it's usually with the last one where the court would say, is this really genuine, or is this person trying to delay, or is he abusing the process? Because he's not giving the court anything to work with. He's not telling the court, but why are you saying that there's some untruthfulness, or there's a possibility that what the applicant is saying is not true? So in those circumstances, the courts have said that the respondent, it's his duty then to come to court and say, I want the matter to be referred to oral evidence or to trial or whatever the case may be. So as I've said before, the court mustn't just accept the say-so of the parties. That is not conclusive. And the question, the issue that the court must determine is whether there is a real and genuine dispute of fact, and whether it's bona fide. And it must be on a material question of fact, not law. We've said that already. Okay. In room hire, where the court discusses these issues, where they talk about that fourth situation, the court says the following. If the dispute is of the last mentioned kind, and if the respondent desires oral evidence, i.e. wishes the applicant to be called for cross-examination under Rule 9, and that would be our 67, such cross-examination is sufficient safeguard for him without requiring the case to be sent to trial. In fact, if he does not ask for or declines an offered opportunity for such cross-examination, the court may decide the matter on the affidavits before it. In the other cases, so it's in the first three situations, where there is a real dispute of fact, and the parties do, except where the parties ask for referral. So if the parties don't ask for referral and there is a real dispute of fact in the first three instances, the court should ordinarily decline to decide the dispute purely on the probabilities as disclosed in the affidavits, and should at its discretion select the most suitable method of employing viva voce evidence for the determination of the dispute. So once the court decides that there is a genuine dispute of fact, especially in the first three instances, the discretion and the decision really lies with the court to decide what to do. And it would be one of the things that are in 67, whether to refer the matter for oral evidence or to trial or to dismiss the application. In the fourth one, if the situation is the fourth one, the court can actually just ignore the situation and see what the respondent does, whether the respondent says, I want the matter referred or not. And if the respondent doesn't ask for it to be referred, then the court must decide the issue on the papers. Because by then, what the court has before it is really just the applicant's version on paper. So the respondent has not put up anything to dispute what the applicant has said. And in those cases, then the applicant would be entitled to the relief it seeks. So a respondent must be very careful if he cannot provide any evidence contrary to what the applicant has said. He mustn't just sit back and just deny and say, I can't say anything to the contrary. I deny it, but I put you to the proof. The proof is in the affidavit already. So you haven't given me anything else, and what must the court do? Then the applicant must get what he has asked for. Okay. But the first three situations is where your discretion arises as a judge. You must then decide what to do. And in those three circumstances, the court can actually, out of its own, decide to refer the matter for oral evidence. It doesn't happen a lot. Most of the time it is when the parties ask for it. But the court has a discretion to, out of its own, decide which process it adopts. So if it doesn't refer for oral evidence or trial, and there's a dispute of fact, it will normally result in the dismissal of the application. Okay. But there's another thing that we will look at, the approach of the court where there is such a dispute of fact, whether or not, and what circumstances the applicant will be entitled to the relief he seeks, and that's the plus con evidence rule that the court applies. So that is a little bit later on. So the circumstances in which the court will refer the matter for oral evidence is where it would be more convenient to do so. The issues are clearly defined, and the dispute is comparatively simple in the sense that it's not many issues that are in dispute. It's not a complicated factual scenario that the court is dealing with, and referring to oral evidence would result in a speedy determination of the dispute. So those are the circumstances in which the court will then rather opt to refer the matter for oral evidence. If the issues are complex or manifold, then it won't make sense. Because when you refer for oral evidence, it would normally just be on a limited number of issues. And in those circumstances, the issues must be clearly defined. So the court will say, I refer the matter for oral evidence on the following issues. So if a party asks the court for referral for oral evidence, they must specify the issues that they think must be referred for oral evidence. In the court's order, the court has to indicate those issues. What the court must also do is identify the witnesses who must come and testify on those particular issues. Normally, the witnesses would be those persons who have deposed to affidavits, but there can also be instances where the court will have additional witnesses come testify, because sometimes a party might not be able to deal with an allegation on an application, on an affidavit itself, but it has a witness who does not want to depose to an affidavit, but if they're subpoenaed, they would come and say something which will help them. Okay. So in those circumstances, the court will allow for other witnesses also to be called to testify, but normally it would be the ones who have deposed to affidavits already. So it would become clear from the affidavits of the parties whether it is necessary for other witnesses to come and testify, or whether the ones who have deposed to affidavits are sufficient. Okay. So we won't be having a trial yet. Here we are talking about oral evidence, so it's not a full-blown trial. So the court is referring you, the parties come and testify, and that's why you limit the issues on which they testify. Because if you refer it to trial, it would be a lot more in terms of issues. But obviously, if something arises whilst the parties are testifying, you as the judicial officer have a discretion. Off the top of my head, I'm not sure. it happens sometimes where the parties, the facts are generally common cause, but there's perhaps one specific factual issue which the parties are arguing about. Let's use a mandamus application, mandament van spoorlie application. Let's say the parties argue about, the issue is about whether or not the person put a lock on the door. No. I can't think of something now, but you see, this is perhaps how you should look at it. Every case has certain requirements that must be met for the person to succeed. Certain essential allegations that they must make in order to be able to succeed. So with a spoliation application, you have to allege that you were in possession, undisturbed possession of the property, and that the respondent has disturbed you in your possession unlawfully, meaning that they didn't have any legal basis for doing so. They didn't have a court order or whatever. They just came and took the law in their own hands. You need to make certain allegations to support those requirements. And so if the parties bring up facts, say for instance, the person is talking about it was in undisturbed possession. So now the respondent comes and says, yes, he was living let's say it was a shop. He was operating the shop, but I also had an office in the same shop. So it was not, he didn't have exclusive possession. I also had possession, and that possession of his has not been undisturbed, because I would normally lock the office because I have a key, and he normally gets, these facts are terrible, but he has to get keys in order to access the property. So I did not dispossess him. He just needed to come and get the keys. So now there's a dispute of that on the papers. And then something comes up in the evidence, and the person says, the applicant comes and testifies, but I had my own key. He never mentioned that in the papers. I had my own key, which I went and I cut it with his permission on this and this date. And there was Peter Pan with us when we were talking about it. And Peter Pan obviously didn't depose to an affidavit. And now we are sitting in court and this comes up. Then the court needs to decide at that point in time, okay, can the person call Peter Pan on this particular issue? And then the court must decide what is going to serve justice between the parties. It's a terrible example. I can't think of much else at this point in time. But so it may happen, because things are very fluid when people are testifying. You can never, sometimes you'll find, even for us, the person will come and they will give you, when you start off with a case, they tell you a story. And as you go along with the case, as the other party also files pleadings and that kind of thing, new facts come up that they never told you. Sometimes you come to court and something is said in court. Then they tell you at that point in time, oh, but so-and-so happened. They've never said this to you, and you've been together on this case for a year, 2 years. So it's very fluid in a court setup, especially when people are giving evidence orally. Sometimes they are reminded of things whilst they are testifying. So it will be within the court's discretion in those circumstances to say, okay, fine, I'm going to expand the issues for oral evidence, or no, I'm not. You should have dealt with it in your application or not. But it's a matter of fairness, and you have to apply your discretion judicially. We are now talking about the situation where the issues are clearly defined. So we know exactly, it's just two factual issues that are in dispute. And we just need 2 witnesses to come and talk about it. And maybe an additional witness who can maybe shed some light on the issue. And we talk about that only when we come and testify. So it will be very limited. And this is why we say one of the other bases upon which the court will refer to oral evidence rather than to trial is because we can have those people in court in a morning session, they finish testifying, and we can determine the dispute just quickly. Sometimes it happens, and that when people start filing affidavits, a lot of issues become contested, and the court cannot determine the matter on paper. So the court then would have a choice between either referring the matter to trial or dismissing the application. So there's a fine line between those two. Because if there's so many disputes of fact, then you shouldn't have come by way of an application. So when the choice has to be made between a trial or dismissing, then you are on shaky ground as the applicant. So the applicant can come back in those circumstances, because the court basically just says you have not proved your case, in the sense of there's nothing for the respondent to answer. Okay, so you can come back. It's similar to an absolution application in a trial. You've dealt with that in the trial action proceedings, right? Remember, you wouldn't come to court with an application if you know that there would be a dispute of fact, because you're also taking a risk as an applicant in doing that, because you run the risk then of this application being dismissed, or anyway going to trial. So the reason why you would have wanted to come with it by way of application is because it's speedier, less cumbersome, and that kind of thing. It's supposed to be cheaper as well. It can become expensive depending on what happens in the application. But that's why you would come by way of application. Otherwise, you would come by trial anyway. So it's for the applicant, which is the lawyer now in this instance, to make a judgment call based on what he knows at that point in time before he decides to come by way of application or by way of by way of trial action proceedings. So it doesn't happen a lot. These things, referring to trial and dismissing and those kind of things, it doesn't happen in a lot of cases, because you would not ordinarily not have people come to court by way of application if they should have actually come by way of trial action. Okay. In this case, I think. So these two cases are very good cases to read to understand these issues better, because it's a very discretionary issue. So it's not a thing where you follow a certain step-by-step process. It's a lot of weighing up of factors and that kind of thing. So when you have to apply your discretion, it's not so simple, and it's not always that easy. So to get some guideline, these two cases are pretty good in giving you the guidelines that you need to determine what you need to do in circumstances like these. Okay. Okay, so how the court looks at whether or not it should refer the matter for oral evidence is, we've dealt with the three things that it needs to look at, whether that is an appropriate case for oral evidence. So in this Hileka versus Levy case, what the court talks about there, it says that if the probabilities are in favor of the applicant's version, the court must be satisfied that a viva voce examination and cross-examination will not disturb this balance of probabilities before it grants the relief sought by the applicant on the affidavits. Now, let's just try and explain that to you nicely. So, if the material facts are in dispute, final relief will generally not be granted on the affidavits. Okay? That's the basic first principle that you must consider. So, the first principle is, if the material facts are in dispute, the court would generally not decide the matter on the papers. I'm saying generally because there's more to come later. So, if you look at the affidavits, there is a dispute of fact. The probabilities are in favor of the applicant. Now, the court must now look at, depending on what the party is asking for, the one who's asking for referral, court must determine whether the viva voce evidence or cross-examination, whether that will disturb those probabilities. So if the oral evidence will not disturb those probabilities, okay, so it's not going to make any difference to the probabilities that are in favor of the applicant. In those circumstances, the court can grant the relief on the affidavits as they are. But if there is a chance that the evidence, oral evidence or cross-examination might tip the probabilities in favor of the respondent, then the court must refer it for oral evidence. Because remember, the applicant is the one who comes to court. He's the one who makes the choice as to the proceedings or the way in which he comes to court, whether he comes by way of trial or by way of application. So the court must lean more lean towards assisting the respondent rather than the applicant in cases where there are disputes of fact. When I say that they must lean towards assisting the respondent is because it's unfair to the respondent to decide the matter on the papers just because, and grant the applicant the relief because on the papers the probabilities are in favor of the applicant. But if oral evidence is called for or cross-examination might change the probabilities in favor of the respondent, then it would be fairer to ask for oral or to refer the matter for oral evidence. Because the respondent didn't have a choice as to how he's brought to court. Okay? He just needs to respond to whatever the applicant has done. In the Khalil case, the court says the following. Naturally, in exercising this discretion, the court should be guided to a large extent by the prospects of viva voce evidence tipping the balance in favor of the applicant. Thus, if on the affidavits the probabilities are evenly balanced, the court would be more inclined to allow the hearing of oral evidence than if the balance were against the applicant. And the more the scales are depressed against the applicant, the less likely the court would be to exercise the discretion in his favor. Indeed, I think that only in rare cases would the court order the hearing of oral evidence where the preponderance of probabilities on the affidavits favored the respondent. So, simply put, if on the affidavits it looks like it's more in favor of the respondent than the applicant comes and says, oops, actually if we do have cross-examination or the matter is referred to trial or oral evidence, then I might be able to make my case stronger. In those circumstances, the court should be less inclined to grant that relief in the sense of referring to oral evidence. Why? Because the applicant should not have come to court by way of application if there might be disputes of fact. Okay. That it's really about what choice the applicant, the fact that the applicant is the one who made the choice. So what you would normally have is the respondent would come and he would deal with the factual allegations made by the applicant, and he will say, see now, if you look at this, there is a dispute of fact, a very genuine and material dispute of fact on this case. This applicant should not have come to court by way of motion proceedings. I'm prejudiced as a respondent because of this. So, and then the respondent can say, the respondent will normally say, dismiss the application. That would normally be the knee-jerk reaction of the respondent in those circumstances. And then the court must look at it and say, okay, there is a dispute of fact. It falls within those first three sets of circumstances. Do I refer for oral evidence or dismiss the application, or do I refer them to trial? So the applicant will look at it and will see, what can I say in reply which might be able to help me to discredit what the respondent is saying. He might have a document to discredit whatever dispute the respondent has raised in his answering papers. And then the court will say, there's no genuine dispute of fact here. Look at what the applicant has come back with now. Or the applicant will say, because of these things, I didn't know this is factual disputes. Does it warrant oral evidence only, or does it warrant a trial? Or, no, Mr. Applicant, you should have known. Because here's a letter showing exactly what the respondent is saying. So why didn't you then, at that point in time, already decide you must come by way of action proceedings? Okay. So it's not just this thing of saying, I don't want to answer you or whatever, and I want to go by way of trial. You must say why you can't deal with the allegations. So the respondent might come and say, listen, I don't know, I cannot deal with these factual allegations. But I spoke to Mr. So-and-so at that point in time, and they actually told me this. I've asked him to give me an affidavit. He doesn't want to depose to an affidavit. He's reluctant. But if given an opportunity, I will subpoena him. And obviously, one would expect any person who is put on the stand to speak the truth, and then it will show that the applicant's case is actually not what it is. So those are the kind of circumstances in which the respondent can actually ask the court to say, refer this matter to oral evidence or to trial or whatever. Okay. So sometimes the respondent will come, and as I was saying here now, he will make certain allegations which, if he's able to prove them eventually, it might disclose a defense. So it's maybe in circumstances where there is a person who has witnessed the situation but doesn't want to depose to an affidavit. Then the court will, in those circumstances, if the court is satisfied this is not abuse, this is not a fishing expedition and so on, then the court will also refer the matter to oral evidence, because then if it doesn't, there would be an injustice. Okay. So you will have here a scenario of this person referring to allegations which would actually constitute hearsay. And in affidavits, you're also not allowed to use hearsay. But it's in a case like this, the court will allow it because it's not given there for purpose of proving what the person is trying to say. It is there for purposes of convincing the court to refer the matter to oral evidence. So it serves a different purpose. Okay. So in those circumstances, the court will allow the hearsay evidence, but it won't rely on it for purposes of determining the issues. It will rely on it to determine whether or not it refers the matter for the hearing of oral evidence, or for trial, or for whatever it might decide then at the end of the day. So again, it's a weighing up of what is being said to determine whether the person is on a fishing expedition, is trying to delay the matter, or is just busy with an abuse of the court's process. So these are the situations where the respondent must come to court. He must be very clear about why he cannot lead the evidence or put the evidence on an affidavit. He has to indicate how he's going to put this evidence before the court, through what witness, etc. Okay. For the court to be able to apply its mind properly to the issue. Okay. So in this situation, the court says, given the opportunity, so the person is basically saying, Given the opportunity, I propose showing that even if the facts alleged by the applicant are true, I can prove a defense. In those circumstances, it would not be an answer to say the motion proceedings must be decided on the version of the respondent, even when the onus of proving the version rests on the respondent, because ex hypothesi, the respondent is unable to produce evidence in affidavit form in support of his version. It would be essential in this situation, postulated, for the deponent to the respondent's answering affidavit to set out the import of the evidence which the respondent proposes to elicit. So he must say what would be the effect of that evidence, what would be the evidence maybe, which he wants to elicit under cross-examination of the applicant's deponents or other persons he proposes to subpoena. So he must say this person is going to come and say A, B, C, and D, and then he must explain why the evidence is not available. Most importantly, and this requirement deserves particular emphasis, the deponent would have to satisfy the court that there are reasonable grounds for believing that the defense would be established. Such cases will be rare, and a court should be astute to prevent an abuse of its process by an unscrupulous litigant intent only on delay, or a litigant intent on a fishing expedition to ascertain whether there might be a defense without there being any credible reason to believe that there is one. But there will be cases where such a course is necessary to prevent an injustice being done to the respondent. So, this is now the crux of it, is what are the material questions of fact? And these basically are the facts which the applicant needs to establish in order to succeed in its application. So, like in a trial, in a trial proceeding, you will have your particulars of claim. You have to make certain necessary allegations in order to for you to have set out a cause of action. Otherwise, there will be an exception. So it's those necessary allegations together with the evidence to prove those allegations. So that's what you have in an application. So it's where there's a dispute on those material allegations, because you see, the applicant is not expected to come and tell everything in his application. Otherwise, your affidavits would be very, very long and thick and not very nice to read. Okay. So the only allegations that they need to make are the essential ones. So where there's a dispute on those essential facts or allegations, that's where it is a material question of fact. So the opposite, obviously, as far as the applicant, the respondent is concerned. So it's those material facts which the respondents must put forth in order to have a proper defense to the application by the applicant. So when the applicant is faced with whether he wants to come to court, or when he decides to come to court, he will have some background facts to the issue that he wants to bring to court. So, I mean, people don't just get up out of the blue one morning and decide, I'm going to sue Lorraine now because she's sitting on my chair. Lorraine doesn't even know I'm upset because she's sitting on my chair. And then I sue her. So there will obviously have been interaction beforehand. And those things you are going to mention in your papers, and the other party is going to respond to those allegations. So these cases happen based on things that have happened already, normally. So sometimes it's about things that might happen, or that's where you'll have come for interdictory relief, where you want to stop somebody from doing something that could harm you. But usually it's about past events. So based on those past events that you deal with in your papers, you will be able to see or foresee what the respondent might say in answer to your case. Obviously, if you did not know what the person is going to come and say in their replying papers, because it's not something you had in your mind, or you didn't know about it, or I don't know, you didn't think that is the way they saw the issue, then the court will then apply its discretion as to whether or not to refer the matter for oral evidence or to trial. So it's where in circumstances where you should have foreseen that a dispute of fact will arise, then the court is more inclined to dismiss the application. Because if you should have foreseen a dispute of fact, then you shouldn't have come to court. So obviously, yes, it is when the parties have filed their affidavits that this will become apparent. The dispute of fact will become apparent. But what will also become apparent is whether or not the person should have foreseen this dispute arising. So that is for the judge to look at and decide on. And that's where you have to assess the papers carefully to determine whether firstly, is a genuine dispute of fact? Is it really about the material questions of fact, this dispute? Or is it about side issues? Remember, a dispute has the main issue, and there are always the side issues that people will mention in the affidavit to fill in the story. Otherwise, the context might not be clear, or the story might not flow, and that kind of thing. So is this dispute really about the main issues between the parties? And that has to do with what case you are coming to court with, your cause of action? Or is it really just about side issues? So remember I said when this is raised by a defendant or respondent that there's a dispute of fact, you can't just accept what he says. You must decide, looking at the papers, is it a genuine dispute of fact here that I'm dealing with? Or is it just the respondent coming here with a knee-jerk reaction, trying to frustrate the applicant, to delay the matter, or to abuse the process? So we'll deal with interdicts. So it depends on what kind of interdict you're looking for. So interim interdicts normally they don't finally determine the issues between the parties. Interim interdicts. So you are trying to maintain a certain status quo pending a final resolution of whatever dispute is between the parties. So you will come to court and you'll say the respondent must be interdicted from selling the car because I have actually bought the car from him and now he's trying to sell something to somebody else, but I've already paid him. But you can't come by way of application with that case, so you're going to ask for an interim interdict pending finalization of an action that you are instituting against him for delivery of the vehicle. So that would be, it's a different situation, that one. So if you want final relief, which is interdictory in nature, you can come by way of action proceedings, or you can come by way of application. So I said there are the two extremes. There's things that are in terms of an act, you have to come by way of application, like a liquidation application, you cannot do by way of action proceedings. Even if there are disputes, yes. 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 Even if there might be a dispute of fact, you must come by way of application because that's what the Companies Act, for instance, says, or the Insolvency Act says. Then there are those that you cannot come by way of application. Those are divorces, for instance, illiquid damages claims. Those must be by way of action proceedings. Anything in between, the question is there a dispute of fact or not? Yeah, so the situation that she's talking about, say for instance the parties are busy with a divorce, there's an action proceeding going on. Now, whilst they're in the divorce, the mother has custody of the child. Now, these days, you have to have the other parent's consent in order to take the child out of the country on holiday. So December comes, it's usually December. There's many of these applications in December. So the mother wants to go on holiday, and the father decides he's just going to be difficult and spiteful. So the mother can come to court by way of an urgent application. And yes, there will be disputes. Usually with those kinds of things, there will be disputes. And the custody issue is still pending in the divorce court because that's one of the issues that the court must decide in the divorce as to who must be the custodian of this child. So the mother comes and she says, I want to take this child on holiday. The father is being difficult. I intend to come back and whatever. The father will then have to come and say what he wants to say. And this is where I said what comes later, the court will use in order to decide whether or not it will grant the relief. In those circumstances, there will be a dispute of fact, but the court can decide that application by following a certain approach to the evidence, or applying a certain approach to the evidence. And that is what I said will come later. So, and that's the other thing that I was talking about is with final interdicts. If the court may, on the papers, decide the matter without referring to oral evidence, the question would be, would the applicant be entitled to the relief? It would depend on what the test that the court applies to the evidence that is before it, and what is the result of that test. So that is what I'm going to deal with later. So in your rules, you will find that there is a form for a notice of motion. And the rule that deals with application starts at, can we put this thing down a little bit? It's a bit hectic here. I'm not sure. Lorraine, when is our break? Hmm? 10:30. Okay. Okay, let's do that before we move on to this next topic here. Okay, so about 10 minutes?
No, 5.
5 minutes? Oh, okay, good.